respectively. Item number 1 for judgment is serial 46 of 2010 with CRL number 42 of 2010.
In the result, JCRLA number 46 of 2010 is allowed. The appellant Nivedita Panda is acquitted of the charge under section 120B of the Indian Penal Code. She be set at liberty forthwith if her detention is not otherwise required in any other case. The appellant Shama Chaudhary is acquitted of the charges under section 302/34 of IPC and under section 201/511 of IPC. He be set at liberty forthwith if his detention is not otherwise required in any other case. CRLA number 442 of 2010 is dismissed. The conviction of the appellant Suryakanta Behera alias Katiki under section 302 IPC and under section 201/511 of IPC, and the sentence passed thereunder stands confirmed. The appellant was directed to be released on bail by order dated 23/2/2015. His bail bonds and surety bonds stand cancelled. He shall surrender before the London Trial Court within 2 weeks from today to serve out the sentence awarded by the London Trial Court, which is confirmed by us, failing which the London Trial Court shall take appropriate steps for his arrest and send him to judicial custody. Before parting with the case, we would like to put on record our appreciation to Ms. Shashmita Nanda, advocate for all the appellants, rendering her valuable help and assistance towards arriving at the decision above mentioned. This court also appreciates the valuable help and assistance provided by Mr. Jateswar Naik, additional government advocate.
I agree.
For judgment, JCRL 26 of 2014.
Cumulatively, the prosecution has meticulously established a cogent, consistent, and unbroken chain that leads inexorably towards the guilt of the appellant, and the principles laid down in Sharad Bridhichan Sarda versus State of Maharashtra have been fully met, as each piece of evidence reinforces the hypothesis of the appellant's culpability and excludes any other reasonable theory of his innocence. The marital discord, last seen evidence, non-explanation under Section 106 of the Indian Evidence Act as to the circumstance of fatal injuries on the deceased, incriminating conduct, recovery of weapon, bloodstain on the wearing apparel, and the medical evidence all interlinked to form a comprehensive and reliable chain of circumstance, leaving no room for doubt, and establishes a strong connection between the appellant's behavior and the eventual tragedy, and the appellant is thus liable for having committed the murder of his wife. Hence, the judgment and order dated 21/11/2013 by the learned Sessions Judge Jajpur is found to be legal and justified, and the conviction of the accused appellant is confirmed. Before parting with the case, we would like to put on record our appreciation to Ms. Chandana Tripathi, advocate for the appellant, for rendering her valuable help and assistance towards arriving at the decision above mentioned. This court is also appreciate the valuable help and assistance provided by Mr. Jateswar Naik, learned additional government.
I agree.
Mention serially plans 564 21 minutes. Appeal bail more than 7 years in custody.
More than 9 years ago.
My lord, if the land acquisition matter old case.
And pardon, my lord. Item number 25 may not be taken today because a part and matter people that will take some time before the Honorable Chief Justice. Item 25. Next week at any time, I indicate.
So who is for the other side?
Other side, last time also he was not there when the case was taken up.
Right, Mr. John Clayton, Senior Advocate, 6 for adjournment. With next week, this matter will be commencing from 18th of November 2020.
Item 26, Lords. Petitioner and OP number 6, they have retired in the meantime, so petitioner has become in process.
The OP number filed in this case.
For OP number 6.
All right. Are you filing any memo of withdrawal or?
I will file.
Please give the Mr. Amir Kumar Mahanti, Land Counsel for the petition. 6 files a memo taking permission of this court to withdraw the writ petition. The memo is taken on record. The writ petition is disposed of as withdrawn. All the interim orders stands vacated.
Item 9, my lord. Item 9.
Yes, yes, it is there. No, that all.
Item 9, permitted to withdraw. Item 9, withdraw.
B.N. Sadangi. Mr. B.N. Sadangi, Land Counsel appearing for the petitioner, files a memo for withdrawal of the writ petition. Memo is taken on record. Writ petition is disposed of as withdrawn.
Pardon to mention, ma'am. My lord, item number 38. Your lordship had heard the matter, had kept it only for my lord, note of
Yes,
submission.
yes,
if the
yes,
lordship
note of.
remember. I am filing a note of submission. My lord, may kindly read.
The other side.
My lord, yesterday when it was taken on board.
No, just pass on it.
My lord, I have already texted him saying that I'll be making a mention. I informed him yesterday.
What is the item number?
My lord, item 38. The only pray, my lord, effective reserve order.
Just yes, obviously.
Grateful. Item number 38.
38 order, the last order that is making a
5th November was the last order.
Then transfer the opposite part number 1 filed a compilation of in court today, which is taken on record. Land counsel for both the parties submitted that they intend to file written note of arguments and some citations within 1 week.
Land counsel for the opposite party number 1 files the written note of argument and citations you have.
And I've also given the citation.
Which are taken on record. Let a copy of the written note with the citations be supplied to the land counsel appearing for the petitioners. Hearing closed, judgment reserved. Interim order passed earlier shall continue till pronouncement of the judgment.
Grateful, man. Deeply obliged. My lord, I have also compiled everything. So, my lord, if there is anything, my lord, may ignore those previous. Deeply grateful.
Somebody would say that I know all these answers, but I could not write in the examination paper. But my candidate know all the answers. You might be knowing that.
My lord, the documents have been duly received by the Tahsildar, my lord. I have filed the
ମନେ ସେ ଆପଣ ଦୁଇଟି ପଠେଇଥିଲେ, ସେ 5ଟା ମାଗିଥିଲେ, ଆପଣ 2ଟାର ଜେରକ୍ସ କପି ପଠେଇଛନ୍ତି। ସେ ଡେଥ୍ ସାର୍ଟିଫିକେଟ ମାଗି ନଥିଲେ, ସେ ମାଗିଥିଲେ 5ଟା ଡକୁମେଣ୍ଟ, ଖାଲି ୟାଦାସ୍ତା ପଠେଇଛନ୍ତି। ତାର ପୁଣି ସେଟା ହଉଛି ଗୋଟେ ଜଷ୍ଟ ଜେରକ୍ସ କପିଟା, ତାର ଟ୍ରୁ କପି ଆଟେଷ୍ଟେଡ ବା କିଛି ନାହିଁ। ତ ଏଇ ବେସିସରେ ଆପଣଙ୍କର କ୍ଲେମ କେମିତି ଆପଣ
my lord, this is not a leasehold. This is the property is not leased out to the petitioners.
ଆମେ କଣ
How can we know?
My lord,
Your case is Khas Mahal lease case.
my lord,
And
my
then
lord.
how can we know?
କିଏ କାହାକୁ ଦେଲା ସେ ଡକୁମେଣ୍ଟ କାହିଁ? ଆପଣ ଯୋଉ ଆଣୁଛନ୍ତି ଯୋଉ ସୋର୍ସ ରୁ ଆପଣଙ୍କର ରାଇଟ ଟା ଆଣୁଛନ୍ତି,
My lord,
ଯେ ଲିଜ ଦିଆ ହେଇଥିଲା, ତାପରେ ଏମିତି ହେଲା ଟ୍ରାନ୍ସଫର, ତ ପ୍ରଥମ ଯୋଉ ଫାଷ୍ଟ ଡକୁମେଣ୍ଟ, where is that?
my lord, that is annexure 1, my lord. That is annexure 1 at page 19. Lordship may kindly come to page 19, my lord.
No, that is a cell deed you are saying, Annexure 1.
Yes, my lord. That is, my lord, the government has executed a registered cell deed in favor of one Bula Behra, my lord.
In 2030, in
1930, my lord.
Why didn't you produce it before the authority?
My lord.
Why didn't you produce it before the authority?
My lord, all Xerox documents.
Why Xerox? They say, as per the OGLS, you need to file the document in original. You file it in original.
My lord,
so you have not complied it.
No, my lord.
You comply the direction of the authority.
Are you just let us be? Are you having all the documents which the collector has mentioned and the Tahsildar has sought for from you?
My lord, all documents are with me. All documents.
Original document. This is the
all. My lord, my lord.
Copy of so and so. All the EU documents.
My lord. All documents are with me.
केवे produce करिए?
My lord, by next week, my lord.
Next week. Let us remand this case on the basis of the statement. We give a fixed time limit. Produces well and good, not produce. So it is to be produced before the concerned who has passed this order.
Collector. An appealable order also under 7.
That is also
appeal to the artist.
They are coming in.
Since it is to be produced before the Tahsildar, we will send it to the collector, and thereafter the collector will again revisit the case.
Yes.
It is on the basis of these documents, non-availability of the documents. He says that this is available, and we'll fix a time limit for the. Okay, this writ petition has been filed by the petitioner so and so with a prayer to set aside the order dated 10/7/2024 passed by the collector and district magistrate Cutter, opposite party number 2. In KLC number 1084/2002 by Danish 13 with a further prayer for direction to the opposite party number 2 to approve the KLC number 1084 of 2002. The impugned order under Annex 13 indicates that when the Tahsildar Sadar reopened the case on 20/11/2023, he informed the applicant petitioners to submit the following documents. So documents would have page number 2 or internal page or running page which is 71 5 documents. Later hide कर देवे 88616 dated 22/11. In response to the said letter of the Tahsildar Sadar, the appellant submitted only 2 documents xerox copy of two documents, that is Yaddas and death certificate of Shahid Nurul Haq, which were neither verified nor certified. Therefore, the collector was of the view that the appellant again failed to produce the original documents as required under OGLS amended bracket ends rules 2010. After going through the case records, the collector came to hold that the recorded tenants are dead and the application was a long back one and for which uh, fresh inquiry was necessitated, and the RI Khasmahal visited the spot on 19/6/2024, and though the applicants were present at the spot, they did not cooperate in the inquiry process. A part of the suit land was transferred by RSD number 3755 dated 36/2005 of the registering officer Qatar without prior approval of the competent authority. The collector further found that there is no mention of any lease deed, public sublease, public subsequent lease deed, nor any connecting documents attached therein on the basis of which the applicant's petitioner's claim could be considered as required under OGLS amended rules 2010, as the said rule prescribes that the onus of adducing evidence in support of the claim lies on the applicants. Since the applicants could not fulfill the requirements of 2010 rules, the collector summarily rejected their claim. The Learned Counsel for the petitioner submits that the original copy of all the documents sought for by the Tahsildar Sadar is available with the petitioner, are available with the petitioners, and they can produce the same before the Tahsildar at any time if an opportunity is given, and they are also ready and willing to cooperate with any inquiry to be conducted in connection with the matter. And therefore, the impugned order be set aside and the opportunity be provided to the petitioner to put forth their case in accordance with law. Land Council for the state has no serious objection to such submission, considering the submission made by the Land Council for the respective parties in order to give another opportunity to the petitioners. We direct that if within 15 days from today, the petitioners produce the original of all the documents as mentioned in the later number 8616 dated 22/11/2023 before the Tahsildar Sadar, it is open to him to conduct any inquiry in accordance with law, and the petitioners in that event shall fully cooperate with the Tahsildar. And after the inquiry is conducted, it is to be submitted before the opposite party number 2, who shall go through the case record, revisit the case records and the documents filed by the petitioners, to be filed by the petitioners. So also the inquiry report, if any, of the Tahsildar Sadar, and pass a fresh order in accordance with law. It is made clear that we have not expressed any opinion on the merits of the case, but this order has been passed just to give an opportunity to the petitioners in the ends of justice. It is made clear that if within 15 days from today, the petitioners do not produce the original documents as required by the Tahsildar by letter number 8616 dated 22/11/2023, the impugned order dated 10/7/2024 passed by the collector Cuttack, opposite party number 2 shall revive. Accordingly, the writ petition is disposed of.
I may be pardoned to mention one thing, my lord. My lord, one thing that
Yes,
the
next.
Tahsildar, as per the requirement of the Tahsildar lease deed, this is not a
You do not know
leasehold land.
whatever you want to do there. Yes.
My lord,
But
it's not
now,
my lord, a flow of title to the hands of the petitioner.
yes,
My lord.
next item.
Sir, there are alternative remedy, otherwise you please.
Item 4.
Oblige.
11/9/2024. Chapter 3 of the order, my lord.
Please read out the order. You
Your Honor,
read from the Wakam. The order dated 11/9/24.
24, my lord.
Just read out from there. Order.
My lord. May I read that?
Yes, no, you read the entire order.
My lord. This matter is taken
No,
up through
leave that. Read from the yeah. Next,
the
faster.
petitioners, namely Ashok Kumar Mahanti, Gopal Krishna Behera, Srimati Baijayanti Mala Nayak, and Sri Prafullo Kumar Samal have filed this writ petition for quashing the order dated 24/7/2024, passed by the Learned Central Administrative Tribunal, Cuttack Bench, Cuttack, in OA number 50 of 2021 under Annexure 1, dismissing their original applications. While dismissing the original applications, the tribunal has taken into account the bylaws of the NWDA vis-a-vis the decision of Honorable Supreme Court in SLP number 3107 of 2012 and SLP number 20425 20426 of 2011. So also the case filed by the CAT Principal Bench, New Delhi, by Rohit Kumar Sethi. Learned counsel for the petitioner submitted that though the aforesaid decision, in the aforesaid decision, it was held that the employees of NWDA are to be governed by the National Water Development Agency Contributor Fund Rules 1982 and not Contributor Provident Fund India Rules 1962, but NWDA has not framed any CPF rules 1982 and such a rule is not in existence, and therefore the petitioners are to be governed by the CPF rules 1962. Mr. Bimbisar Das, senior panel counsel appearing for the Union of India, receives a copy of the writ petition in court today. Let Mr. Das obtain specific instruction as to whether there is any such rules, namely National Water Development Agency Contributor Provident Fund Rules 1982 or not, and if it is in existence, produce the copy of the said rules on the next date, which is fixed to 24/9/2024. Then 24/9/2024, Mr. Bimbisar Das, learned senior panel counsel appearing for the Union of India, submitted that instruction has already been sought for in terms of the order dated 11/9/2024, but the same has not been received and therefore the matter may be taken up on some other day. And then learned counsel for the petitioner has no objection, leaves this matter on 28/10/2024, my lord. Then matter came before our lordship on 4/11/2020.
It was adjourned.
Yes, my lord.
You objected to that adjournment.
My lord.
Yes, Mr. Padhi.
Yes, my lord. This Mr. Now I have related to within 2-3 councils. Let's keep it to some other day because the Mr. Das is joining their side.
No, I know that, but you are just to find out if any such rules is there. I hope that we hope
Yes,
that you have got all the orders with you.
Exactly, man. I heard my learned friend is and it, yes.
National Water Development Agency Contributory Fund Rules 1982. Whether any such rule is there or not, just because the
Exactly.
orders mentioned that they are to be governed by that rule, particular rule. So
Yes, ma'am.
that is the reason he said that there is no such rule. So it's a simple thing that has been reflected in order dated 11/9/2024. So that is available in High Court website and it must be available also with you.
Yes, I'll upload it, my lord. I'll
Just,
download it and I'll send this particular order to the department immediately.
The reason being, it was never saw the light of the day till the matter was with the Central Administrative Tribunal. That is how.
Just to find out that whether any such
I got the point, man. I got the point immediately. I'll tell you. Immediately.
Okay. Mr. Padhi, P.K. Padhi, Lenin, Deputy Solicitor General of India, for the submits that he will make necessary correspondence with the concerned department regarding the availability of National Water Development Agency Contributory Fund Rules 1982 existence legal, and some more time may be granted so that if such rules is in existence, he will produce a copy of the same on the next date. List this matter in the week commencing from 25th ରେ ଥାଉ ଖାଲି ଏତି ରୁଲ୍ ଟା ଅଛି ନା ନାହିଁ ଆଉ କଣ ଆଉ ଯଦି ଥିବେ ଆପଣଙ୍କୁ ଯୋଉଟା କପି ପଠେଇଦେବେ
Sir, ଆଉ ଟିକେ time.
ଆଚ୍ଛା second December ରଖୁଛୁ
Fine, man. Yes. Mr. Manoj Mishra is there. Manoj Pati is there. He will pass on the slip for about the appearance of different councillors. Thank you.
council को ना ଯଦି ଅଛି ଦେଇଦିଅନ୍ତୁ अच्छा प्लानिंग काउंसिल फॉर द पिटिशनर को नाम लिखिदेବେ मिस्टर स्वपन कुमार ओझा एंड काउंसिल प्रेजेंट ବୋଲି କରିଦେବେ अच्छा लीज दिस मैटर along with the जो connected matters सहित ଆସିବେ
All the matter come annually.
right 1/12/2024 अच्छा ତା ଦେହରେ ବିଭିନ୍ନ କାଉନସିଲ ଅଛନ୍ତି ଦେଖିଦେବେ ସେ ଯୋଉ ଲିଷ୍ଟ ଟା ଦେଲେ ବିଭିନ୍ନ
That's
କାଉନସିଲ
why I asked make a system slip already.
Okay. CGC ଗୁଡାକ ଚେଞ୍ଜ ହବ ବାକି ମିଷ୍ଟର ପାଣିଙ୍କ ନାଁ ରହିବ
Item 5.
It's made a representation under Annex 3.
Annex 3 to be disposed of.
For 3 months.
OP3.
Yes.
ଆଗରୁ ସେମିତି ଅର୍ଡର ହେଇଥିଲା କି
Yes, my lord.
ଅଛି ଫାଇଲ କରିଛନ୍ତି ଆପଣଙ୍କ ପାଖରେ କପି ଅଛି କି
No, sir.
disposed of.
Yes, ma'am.
ନମ୍ବର ଦେଇପାରିବେ ଗୋଟେ କେସ ର ନମ୍ବର ଦେଇପାରିବେ ଯୋଉଟା ଆଗରୁ ଡିସ୍ପୋଜ ଅଫ ହେଇଛି
No,
ଆପଣ ପୁରା କରିଥିଲେ ନାଇଁ ଆଚ୍ଛା ହଉ ଠିକ yes next
Item 6.
yes Mr. Mahanti ହେଇଥିଲା କି ନା first time
My first time.
pass over କର
Item 7.
Lordship, I'm standing for Sibna Bishwal. Lordship, he's been appointed as a additional standing counsel. So, Lordship, week time may be granted. Okay. It is mention is made on behalf of Mr. Shivanarayan Bishwa that he has now become the additional standing counsel, and some other counsel is likely to be engaged for conducting the case on behalf of the petitioner, and the matter may be adjourned to some other date. It is this matter in the week commencing from 2nd December 2020. Published.
Item 8.
8 minute, please, minutes.
Before hearing my learned clear, can I make a submission with due permission, my lords? In this case, I have already entered appearance for the sole opposite party, my lords. For last 5 years, I am without any job and salary. Let my senior solve a copy so that this matter can be disposed next statement.
You are appealing for whom?
The sole opposite party,
Sanjeevani.
my lord.
Your name is there.
My lord.
What do you want from him?
I want a copy, my lord, of the report.
So you
Oh,
have
they
not
have
been
not-
served with a copy?
No, you are
No,
not.
I have entered
Private.
appearance.
I've seen it.
Today appear
For
करो.
first time, my name.
Oh, it is a new matter.
Yes,
My
New matter, fresh admit.
Oh, all right. Your good name is
Nirmal Ranjan Raut.
Mr. Nirmal Ranjan Raut, Land Council, has already entered appearance for the opposite party, Sanjeevani Raha, and submits that he may be served with a copy of the writ petition so that he will take necessary instruction in the matter, and the matter can be disposed of.
Next week, my.
I don't dispute that. I will tell. In the meantime, he has filed a contempt petition. Contempt petition.
I don't proceed that content.
Oh, okay.
क्या लिखा है? All in terms of the-
Put up this matter. You give it by next week.
Today I am just not having.
Let Mr. Patnaik and senior advocate pass on the copy of the writ petition to the handed over for them. Handed over
And
the
junior
copy
is
of the writ petition to the Land and Council for the opposite party today. Matter be listed in the week commencing from 25th of November 2024. It is brought to the notice of this court by Mr. Patnaik that a contempt petition has been filed before
Tribunal.
in this court.
No, tribunal.
For the tribunal in connection with this case against the petitioner. The Land and Council for the opposite party submitted that till next date he will not pursue the contempt petition in the tribunal. Put up this matter. Hello, 25/11/2024. Yes, next.
Problem.
Item 10.
Land acquisition notification for NALCO is under challenge. As in when the 2006 notification was land acquired for the private company was remained unutilized, my lord. So, my lord, similar matter has been listed today after notice matter item 46. This matter, I mean, permitted take notice to the party, my lord, as in this matter may
किसके number को हुई थी?
item
40?
46. That's of cases is there.
Just a minute.
Is similar issue, but here the land acquisition for different.
46 रे कौन order pass is ठीक देखना.
That notice has been.
Yes, just. Okay, the formalities बड़ा का चल जाओ, Mr. Nayak. Land and Council for the petitioner submits that this matter is connected to item number 46, which has been listed today for final disposal. And therefore, notice may be issued in this matter also, so that it can be heard together with all the matters listed in item number 46. The Land and Council for the state has no objection. Stop. Issue notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Land additional government advocate accepts notice on behalf of victim.
Copy number 1 to 4 and 8.
Just a minute. No, it's the 1 to
1 to 4.
item number 10.
Item number 10, 1 to 4.
Just
And copy number 8.
yes.
1 to 4 and 8, my lords.
List. Petition ଟା ବାହାର କର। Item number 10 ର writ petition ର copy ବାହାର କର। Land Council for the state accepts notice on behalf of opposite parties number 1 to 4 and
8, my lords. SP on good.
8 है
Again.
item number 8 ଏମାନଙ୍କ ପାଇଁ
5, 6, 7.
5,
Okay,
6
number for Mr. Pradeep Mahanti, senior counsel for the IDCO will accept notice, my lord.
for 5
Yes, my lord. And 6 and 7 by registered post.
acha it is submitted at the bar that Mr. Pradeep Mahanti and senior advocate used to appear for the IDCO. Let a copy of the writ petition be served on Mr. Mahanti and his name be reflected in the cause list henceforth. Stop. Requisites for issuance of notice by speed post with proof of delivery for opposite party number 6 and 7 shall be filed by 20th.
Yes,
by next week, by next week. Put up this matter along with so item number so in the week commencing from 16th of December 2024. Counter affidavit, if any, be filed in the meantime.
Notice on IA also. On IA notice.
IA notice issue. All right.
This may be in the bottom of the item 46.
It will be added to that item number 46 and will be listed on 16th December. That will happen. In item number 46, you are the counsel?
Yes, ma'am.
Okay.
All batch of this.
Item 11.
May please, your lord. One of the petitioners, sir, please use the welcome. What is your prayer here?
My lord, I have challenged the impugned possession notice dated 23/10/2020.
13/4 notice you are challenging.
My lord, I may permitted to place for a few moments, my lord. The present petitions are minor child of unfortunate girl of deceased, my lord, deceased and mortgage. The father of the petitioners taken loan in the year 2022, your lordship, and on 12/11/2023 he died in a road accident. Thereafter, after 2 days, their mother committed suicide, not tolerating the trauma. Thereafter, after the death of the both, the mortgagee was mother of the petitioners, my lord. And after the death of both the borrower and mortgagor, the bank has initiated securitization proceeding after 8 months of their death, my lord, against a dead person. And no notice was ever received by the present petitioners, and possession notice has been issued.
Raise all your contention before the appropriate forum.
My lord, what happened, my lord? I may permit it a few minute, my lord, because the present petitions are minor. Though the CWC is paying money to them, they could not able to get that money because there is no legal guardian at all, my lord. And they will fail to give the your lordship. I appeal before your lordship's consent, my lord.
The Supreme Court.
My lord, because it is a peculiar case, for that reason I am. But the bank is going to take possession of a minor property, my lord.
Yes, next item.
Item 12.
Your Lordship, I only one prayer, my lord. My lord, the statutory fee may be because they are minor, my lord.
Approach there, they can file.
Your Lordship may say some.
He is a judicial officer, is there to adjudicate the matter.
Your Lordship may say as because they are minor.
No, we cannot. You have to substantiate it in that forum, and necessary orders can be passed on your application. Yes, next.
Item 12.
You are appearing for the Odisha Gramya Bank.
Yes.
Give the not a big.
Item 12. May I please, your lord. Similar matter, your lordship, that is case relates to enhancement compensation. Your lordship, as past order, I have given that.
Annex
All these cases. Your
Okay.
lordship.
Item 13.
ଆଗରୁ କିଛି ଅର୍ଡର ପାସ୍ ହେଇଛି ସିମିଲାର ଦେଇ ଦଉନାହାନ୍ତି ଗୋଟେ କପି ନାହିଁ କପି ନାହିଁ ନମ୍ବର ଅଛି କେସର ନମ୍ବର ବି ନାହିଁ
Copy number 2 package.
କପି ନମ୍ବର 2 ପାଖରେ ଅଛି
To dispose.
କରିବ ହେଲା
Item 14.
ଦୁଇ ହଜାର ଉଣେଇଶରୁ ପେଣ୍ଡିଂ ଅଛି କୋଉଠି ପେଣ୍ଡିଂ ଅଛି ପ୍ରେୟାରରେ କିଛି ଲେଖିଲେନି କୋଉଠି ପେଣ୍ଡିଂ ଅଛି ବୋଲି ଆପ୍ଲିକେସନ ଦେଇଥିଲେ ଶୀଘ୍ର ଡିସ୍ପୋଜାଲ କରିବା ପାଇଁ କଣ ହେଲା ଅର୍ଡର ପେଣ୍ଡିଂ ଅଛି ନା କଣ କାହିଁ ସେ ନମ୍ବରଟା କହୁନାହାନ୍ତି
No, that is the way.
ତାକୁ ଶୀଘ୍ର ଶୁଣାଣି କରିବା ପାଇଁ କୌଣସି ଦରଖାସ୍ତ ଦେଇଥିଲେ ଟେପ୍ଟ ରିକଭରି ଟ୍ରାଇବୁନାଲରେ ଦରଖାସ୍ତ ଦେଇଥିଲେ ତାର ଗୋଟେ ନମ୍ବର ହୁଏ ସେ ନମ୍ବରଟା କାହିଁ କୋଉଠି ଲେଖିଛନ୍ତି ମୁଁ ଗୋଟେ ଆମେ ଦରଖାସ୍ତ ଦେଇଥିଲୁ ଆଉ ଟ୍ରାଇବୁନାଲ ଏପର୍ଯ୍ୟନ୍ତ କୌଣସି ଅର୍ଡର ପାସ୍ କରିନାହାନ୍ତି ଲେଖିଛନ୍ତି ଆଉ ତା ନମ୍ବର କେତେ
No, you have not mentioned about submission of any application for early disposal. No.
କିଛି ତ ନାହିଁ ଆପଣ ଶୁଣାଣି ହଉନି ବୋଲି ଶୀଘ୍ର ସେଠିକି ପଳେଇ ଆସିଲେ ତ ଯେତେବେଳେ ଆପଣ ଆମ ହାଇକୋର୍ଟରେ ଯେତେବେଳେ ପେଣ୍ଡିଂ ଅଛି ଆପଣ ଷ୍ଟ୍ରେଟ୍ ପଳେଇ ଯିବେ ସୁପ୍ରିମ କୋର୍ଟକୁ ଯେ ଗୋଟେ ଡାଇରେକ୍ସନ ଦିଆଯାଉ ହାଇକୋର୍ଟକୁ ରିକ୍ୱେଷ୍ଟ କରାଯାଉ ଏଠିକି ଯଦି ଆପଣଙ୍କର ଶୀଘ୍ର ଶୁଣାଣି ପାଇଁ କୌଣସି ଅର୍ଜେନ୍ସି ଅଛି ଆପଣ ମାନେ ମେନସନ କରୁଛନ୍ତି ନା ନାହିଁ ଯେ ଆଜ୍ଞା ଏଇ ମ୍ୟାଟରଟାରେ ଏଇ ଅର୍ଜେନ୍ସି ଅଛି ଏଟାକୁ ଟିକେ ଶୀଘ୍ର ଶୁଣାଣି କରୁ ଆମେ ଅର୍ଡର ପାସ୍ କରୁଛୁ ନା ନାହିଁ ତ ଏଠି ନ କରିକିନା ଆପଣ ଯଦି ସିଧା ପଳେଇବେ ସୁପ୍ରିମ କୋର୍ଟ କେମିତି ହବ ତେଣୁ ସେଇଥିପାଇଁ ଆମେ ପଚାରିଲୁ ଆପଣଙ୍କୁ ଯେ ଆପଣଙ୍କର ଅର୍ଜେନ୍ସି କଣ ଏ ମ୍ୟାଟରର ସେଥିପାଇଁ କୌଣସି ଦରଖାସ୍ତ ଦେଇଥିଲେ କି ଶୁଣାଣି କରିବା ପାଇଁ ଯଦି ଦେଇନାହାନ୍ତି ତ ସେଠି ଦେବେ ଗୋଟେ ଦରଖାସ୍ତ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ୱିଡ୍ର କରିନିଅନ୍ତୁ ସେଠି ଦିଅନ୍ତୁ ଦରଖାସ୍ତ that will be considered in accordance with law why we will pass the order ଆମେ ସେଇ ଅବଜରଭେସନରେ ଡିସ୍ପୋଜ କରିଦେବୁ ଦେଖନ୍ତୁ this writ petition has been filed for a direction to the opposite party number 1 debt recovery tribunal quarter to dispose of OA case number 389 of 2019 within a stipulated time period. When you put a question as to whether any application has been filed by the petitioner before the learned DRT for expeditious hearing, the answer was in negative. Let the petitioner file an application for expeditious hearing of the said OA, which will be considered in accordance with law, particularly taking into account that 5 years have already been passed since the date of institution of the original applications. With the aforesaid observation, the writ petition is disposed of. Yes.
Item 15.
IF for bail and lordship.
ଆପଣ ଗତ ଥର କୁହାଯାଇଥିଲା ଗୋଟେ କପି ଦବା ପାଇଁ
Yes, sir, lordship. I have already.
ନାହିଁ ଜଷ୍ଟ
ନାହିଁ କହୁଛନ୍ତି ଆପଣ କେବେ ଦେଲେ କାର୍ଡ 4/11 ଅର୍ଡର ହେଇଥିଲା
ଅଫିସରେ ଦେଇ ଦେଇଛନ୍ତି
ଆପଣଙ୍କର ଅଫିସରେ ସାମିଲ କରୁନାହାନ୍ତି କଣ ପାଇଁ କପିଟେ ପାଉଛନ୍ତି ସେଠି ଅଫିସରେ ଗୋଟେ କାଉଣ୍ଟର ଖୋଲିଛନ୍ତି
ଆଜ୍ଞା
ତେଣୁ କନସର୍ନ ଇଏରେ ସାମିଲ କରିବା କଥା ଆଉ ଏଠି ଗୋଟେ ଦେବେ ସେଠି ଗୋଟେ ଦେବେ ତାହେଲେ ସେଠି କାହିଁ ବସୁଛନ୍ତି ଖୋଲିଛନ୍ତି କାହିଁ ଅଫିସଟା କାଉଣ୍ଟରଟା କାହିଁ ଖୋଲିଛନ୍ତି whoever receives it
ଆଜ୍ଞା
his duty is to
Attach with the
attach
record.
it to the concerned case file ତେଣୁ ଆପଣ ଇମିଡିଏଟଲି
ଆଜ୍ଞା
ତାଙ୍କୁ ପଚାରନ୍ତୁ ଏବଂ ଏ ମ୍ୟାଟର ଗୁଡାକ ଆଡଭୋକେଟ ଜେନେରାଲଙ୍କ ନୋଟିସକୁ ମଧ୍ୟ ଆଣନ୍ତୁ
ଆଜ୍ଞା ଆଜ୍ଞା
ହେଲା so that ଗୋଟେ ଥର ତାଙ୍କୁ ଡାକିକିନି ଟିକେ ପଚରା ପଚରି ହେଇଗଲେ ଆଉ ସେମାନେ କରିବେ ନାହିଁ ବୁଝିଲେ ନା
ଆଜ୍ଞା
the learned counsel for the state submits that as per the order dated 4/11/2024 he has the learned counsel with the interim application. However, the learning counsel for the appellant produced the receipt of the SG office to show that the interim application copy has already been served. The learned counsel for the state submits that he will find out the interim application from his office and take necessary instruction in the matter, and the matter may be taken up on some other day. Put up this matter in the week commencing from 25th of November 2024.
Item 16.
Letter of senior superintendent circle Cutter at flag X may be seen. Conta dekhi on letter seen. Eta kebe ka letter ta purna letter ta 2020 eta COVID word par outcome aschi MC number so and so for bail of appellant number 3 MC number so and so for bail IN number so and so 1 and 2 IN number so and so for interim bail Advocate Saroj Ranjan Security and associates filed Nama person without taking consent of previously engaged. Here the aspirant and his associates filed Nama for appellant number 1. Advocate Ashok Das and associates filed. कितने जन फाइल को जाए? Total कितने जन appellant असन? Appeal memo to वर्क में?
Well, also may call this matter next week on behalf of Mr. Ashok Das.
Ashok
Das.
Yes, ma'am.
So he is appealing for which appellant? Wakalat now for appellant number 1 filed, Pasha.
Not for the appellant, respondent.
You are for the respondent.
Yes, ma'am.
No, we are. Who is for the appellant? The appellants. Oh, Mira goes for another person. She would have gone on.
3-4 ଜଣ ତା ଦେହରେ ଚେଞ୍ଜ ହେଇଯିବ
6ଟା କେସ୍ ରିଲେଟେଡ ଏଥିରେ ଯୋଉ 81
56, 57, 62, 84, 92.
and 81
1, 2, 3, 4, 5ଟା case ଅଛି.
କୋଉଟା?
With the present one, 81, there are 5 cases.
ଏଇ particular matter ରେ
ଏଇ particular matter ରେ ଆସିଯାଇଛି ଏଇଟା.
କୋଉଟା?
ଏ କୋଉ କେସରେ କିଏ ଅଛନ୍ତି?
ଆଚ୍ଛା,
ନାଇଁ ଏଇ କେସରେ ଏଇ କେସରେ ତ ଗୁଡାଏ ଆଡଭୋକେଟଙ୍କ ନାଁ ଅଛି ଅନ୍ୟ କେସରେ ଯିଏ ଅଛନ୍ତି ତାଙ୍କ ନାଁ ତ ରିଫ୍ଲେକ୍ଟ ହେଇଥିବ ନା ନାଇଁ ସବୁ ଗୁଡାକ ଆଧିରେ ଲେଖା ହେଇଛି
ଏଇଟା ନୋଟିଂ ରେ ଖାଲି ୱିଥ୍ ହେଇକି ଆସିଛି ସବୁ କେସ୍ ଗୁଡାକ
individually ଅଛି କି ଲॉयर्स का ना ଅଛି
56
ତାହେଲେ
up to 2015 ଟା ବାହାର କିଏ ଆଡଭୋକେଟ ଦେଖିଆ
56
ଏ 56 ରହୁଛି ଏକେ ବରାଳ ଏମଆର ଖଟୁଆ ଏଟା ତ ପେଣ୍ଡିଂ ଥିବ ନା आदरे भी अशोक दास अछंती रेस्पोंडेंट ପାଇଁ ତେଣୁ ସେ advocate separate advocate ତାଙ୍କ ନାଁ ତ reflect ହେଇନି ତେଣୁ ତାମାନେ ଏଇ ଯୋଉ particular matter ଟାରେ CRLA number 81 of 2018 ରେ ଏତିକ advocate file କରିଛନ୍ତି वकालतनामा from time to time ଗୋଟେ କାମ କଲେ ହବ ସେଇ ଯୋଉ ମ୍ୟାଟର ଗୁଡାକ ଏକାଠି ଲିଷ୍ଟ ହେଇଯାଇଛି ତା ତଳେ ଲେଖା ହେଇଛି ସେଗୁଡାକ ୱିଥ୍ ହେଇକିନି ତାଙ୍କ ଆଡଭୋକେଟଙ୍କ ନାଁ ରିଫ୍ଲେକ୍ଟ କରିକିନା ଆସୁ କାରଣ ସବୁଥିରେ ଅନେକ ଆଡଭୋକେଟ ଅଛନ୍ତି ଆଉ ତା ଛଡା ଆପଣ ଇନଷ୍ଟ୍ରକ୍ସନ ନେଇଯାଆନ୍ତୁ ଏଇ ଯୋଉ 3 ଜଣ ଆପେଲାଣ୍ଟ ଆଜ୍ଞା ଏଇଥିରେ ଅଛନ୍ତି ସେମାନେ କାହାକୁ ଏନଗେଜ କରିବାକୁ ଚାହୁଁଛନ୍ତି କାରଣ ଏତେ ଜଣଙ୍କ ନାଁ ସବୁ वकालतनामा ଯିଏ ପାରିଛି ସିଏ ସାଇନ ହେଇଛି ତ ତେଣୁ ସେ କାହାକୁ ଏନଗେଜ କରିବାକୁ ଚାହୁଁଛନ୍ତି ଆଉ ଆକର୍ଡିଂଲି ସ୍ଟେପ୍ସ ନେବେ କି କହିବେ ଆପଣଙ୍କ ଜରିଆରେ ସେ ଆଡଭୋକେଟଙ୍କୁ ରଖିବା
ଭିଜିବିଲିଟି ଏତେ ଭର୍ତ୍ତି ଯେ ଭିଜିବିଲିଟି ନାହିଁ
କୋଉଥିରେ
ଏଇ ଯୋଉ ବିନାମାରେ
81
ବିନାମାରେ 56 ରେ
56 ଟା ସେପାରେଟ ଲିଷ୍ଟ ବି ଅଛି
ଆସିନି ପରେ ସେ ସବୁ ଏମିତି ହେଇକି ଆସିଛି ନମ୍ବର ଅଫ ପର୍ସନ୍ସ there are 11 persons
କିନ୍ତୁ ଆଗରେ ହଉଛି 3 ଜଣ ଏକା ଆସିବେ এটা সেপারেট লিস্ট হলে এମାନେ হয়তো পড়ে আসবে একেবারে যেমন ফাইট করতে লেখନ୍ତୁ CRLA number 81 of 2081 though this matter has been shown in the cause list to have been listed with CRLA number 56 57, 56, 57, 50, 62, 84, and 92 of 2018. But all those matters are required to be, should be separately listed along with CRLA number 81 of 2018, showing the names of the concerned advocates in those criminal appeals. Stop. CRLA Sapparagale. This CRLA 81 of 2018 has been filed by Tutu alias Sorojana, Sonia alias Srikant Jena, and Sipu alias Niroj Kumar Jena. Different advocates have filed power at different point of times for these 3 appellants. Let the Land Council for the state obtain instruction through the concerned jail superintendent as to which advocate the appellants intend to engage want that their case shall be conducted by the advocate, concerned advocate, be brought to the notice of the court in writing. The matter be placed. Who jail ଅଛନ୍ତି ଜାଣିଛନ୍ତି ତ वकालतनामा ସାଇନ ହେଇଛି 14 છે କଟକରେ ତ ଅଛନ୍ତି ଆଉ କଣ ବୁଝିଲେ କଟକରେ ଅଛନ୍ତି ତେଣୁ ଇନଷ୍ଟ୍ରକ୍ସନ ସୁପରିଟେଣ୍ଡେଣ୍ଟକୁ ତାଙ୍କୁ ଡାକିକି ପଚାରି ଦିଅନ୍ତୁ 81 ରେ କେବଳ 81 3 ଜଣ ଆଉ ତାଙ୍କ ନାଁ ବି ଲେଖିଦେଲୁ ଅର୍ଡରରେ କପି ଆପଣ ନେଇଯାଆନ୍ତୁ ଫ୍ରି କପି ଅଫ ଦି ଅର୍ଡର ବି ହ୍ୟାଣ୍ଡେଡ ଓଭର ଟୁ ଦି ଲାଣ୍ଡଲର୍ଡ ସେଇ 3 ଜଣଙ୍କୁ ପଚାରି ବାକି ଗୁଡା ସବୁ ସେପାରେଟଲି ତା ସାଙ୍ଗରେ ଲିଷ୍ଟ ହବ କିନ୍ତୁ ଆଡଭୋକେଟଙ୍କ ନାଁ ରିଫ୍ଲେକ୍ଟ କଜ ଲିଷ୍ଟରେ ହେଲା
Mr. Das here for informant.
Mr. Ashok Das, Land Council for the informant is present for that. এটা আসিବ 25 ତାରିଖରେ ଆଉ କଟକ କଥା Yes.
Item 17.
No, please. Well, I have received the judgment copy on 6th, madam.
In that matter,
Yes, madam.
written note of submission has been given. We have kept the judgment.
Item 38.
I will frame my lord, madam. I have to your lordship's query, I have found 3 judgments on that.
Whatever you want to
File it.
give it. There is no problem.
Clarify
No, I have clarified it.
You file it in his absence. How can you clarify? It is we have closed.
I will file the written note
हाँ,
on Tuesday.
No,
मैं पठेबी
we
टा
have
approve
kept the
हेले.
judgment reserved, so you file it.
But I will.
We have already passed the order. The order must have been, you want to file it, file. If you file it by Monday, it will be accepted, but we are not
But I will
passing.
file on Tuesday. They will bring
You
approval
do
on.
the needful whatever you want to do, but we have kept the judgment reserved and mentioned that only the London Council for the opposite party has filed it. That's
Mr.
all.
Mr. Raguri, you will be getting 3 days time now. You can file it on Monday.
We are giving you.
Monday time देते हैं.
हाँ दियंतु.
ଦିଅନ୍ତୁ Monday ଆପଣ କହୁଛୁ
ଆପଣ ଦିୟନ୍ତୁ.
କିନ୍ତୁ ଆମେ ତା ଦେହରେ ଲେଖୁନୁ, but in the judgment it will be reflected that you have filed subsequently. But 2 days order, since you are not filing, we are not mentioned. All right, yes.
I am filing the citations.
Whatever, you file it.
File. তাহলে ଆଜି ଯଦି ଫାଇଲ କରୁଛନ୍ତି
हाँ citation.
ସାଇଟେସନ ଅଣ୍ଡରଲାଇନ କରିଛନ୍ତି କୋଉଟା ରେଲେଭାଣ୍ଟ ପାରାଗ୍ରାଫ
ଭିତରେ ଉପରେ ମେମୋ ସାଇଟେସନ ପାରାଗ୍ରାଫ
हाँ ठीक है.
ଲେଖା ହେଇଛି ତ
ହଉ.
ଆଉ ନାଇଁ ନାଇଁ
ठीक है ठीक है. फाइल ले दे.
କି ଆଇଟମ ନମ୍ବର
38.
38 ରେ କିଏ ଡିକ୍ଟେସନ ଦେଇଥିଲେ ତାହେଲେ ମାନେ ଲେଖିଦେବେ ନେକ୍ସଟ ମିନିଟ ଜଷ୍ଟ ଏଇଟା ଆଡ କରିଦିଅନ୍ତୁ 38 କରିଦେବେ ଯେ ଭବାନୀ ଶଙ୍କର ରାୟଗୁରୁ Learned Central Government Council filed some citations with a memo which is taken on record. এটা just add କରିଦେବେ ତାପରେ judgment ବାକି ଯାହା ଅଛି ସବୁ ରହିବ. Yes. Now you place this item number 70. Yes.
In item 17, your lordship, upon that amicus curiae,
Yeah.
I have got the judgment on 6th, my lord. On 6th, I have got the judgment. My lord, may I pray this depositions and other relevant soft copy be supplied so that it will be confident.
No, why are you not giving your pen drive? Entire records will be given to you.
Yes, ma'am, I will give the pen drive.
No, ଆଜି ଦେବେ ନା
ଆଜି ଦେବି
ଆଜି ମ୍ୟାଟରଟା ଅଛି ଆପଣ ଅନ୍ୟ ଦିନ ଆଣିବେ ସେ ମ୍ୟାଟର ଲିଷ୍ଟରେ ନଥିବ ସେ ଆପଣଙ୍କୁ କେମିତି ଦେବେ ଆଜି ଏଇଠି ଦେଇଦେଲେ ସେ ଦେଇଦେବ ଆପଣଙ୍କୁ ହେଲା ବୁଝିଲେ ନା ପେନ୍ ଡ୍ରାଇଭ ଗୁଡା ଆପଣଙ୍କ ନାହିଁ କୌଣସି ଫ୍ରେଣ୍ଡର ନେଇ ତାପରେ ଆପଣ ନେଇଯିବେ ହେଲା ତାଙ୍କୁ ଦେଇଦେବେ ହଁ ଲେଖନ୍ତୁ ମିଷ୍ଟର ଭବାନୀ ଶଙ୍କର ରାୟଗୁରୁ the Land Council was the London amicus curiae submits that he has received the copy of the impugned judgment of the London trial court, but the deposition copies have not been supplied to him. Let the registry supply the deposition copies and other documents except the case diary to the Land Council, London amicus curiae in his pen drive. Aji ଦେଇକି ନେଇଯାଆନ୍ତୁ. Matter to be listed in the week commencing from 25th November 2024. Yes. କୋଉଟା
ଟିକେ ଖାଲି କହିବେ
ସେ ମ୍ୟାଟରଟାରେ ପ୍ରଶ୍ନ ଉଠନ୍ତୁ ତାଙ୍କର ଆବସେନ୍ସରେ ଆପଣ
ମୁଁ କିଛି
ଯାହା କହିବେ ଲେଖିକି ଦେଇ ଆପଣ ଆମ ଇଏ ଦେଲେ ଆଉ ଯାହା କହିବା କଥା ଲେଖିକି ଦେଇଦିଅନ୍ତୁ ହେଲା
ଦିଧାଡି ଖାଲି କହିଦେବା
ନାଇଁ ନାଇଁ ଦିଧାଡି ନୁହେଁ ଦିଧାଡି ଆମ ଅନ୍ୟ ମ୍ୟାଟର ଅଛି ଦିଧାଡି କେସ୍ ଆଇଟମ ନମ୍ବର
Item 18.
Nobody is there. Pass over to him.
Item 19.
My pleasure. Last occasion we received that.
supplied the bail order copy of the co-accused Chakra Dhami to the London Council for the State in court today, who seeks some time to go through the case records, to also the bail order to answer the claim of parity. Court of this matter will be commencing from 25th November 2024.
Item 20.
May I please, Your Lordship? I'm appearing through virtual mode, Your Lordship. In the present case, the petitioner has been languishing inside custody since 16/5/2011, Your Lordship. On the last occasion, it was listed on 29/2023, wherein the London State Council submitted the petitioner has got 2 criminal antecedents.
So, what is your reply to that? Have you filed any comprehensive affidavit relating to the status of those 2 cases?
So far, no, Your Lordship. So far, my instruction goes, it's a very old case. It might have been disposed of.
No question of might have been disposed of. You are to put on record your statement.
With regard to that, I will take instruction, Your Lordship.
All right, because this is the recent instruction he has received from the IIC Kharbal Nagar police station. If you say that the instruction is not correct, then you are to controvert it by filing your comprehensive affidavit. For the petitioner, appellant exam. 6 affidavit relating to the status of the 2 cases which are stated to have been pending against the appellant as for the instruction received by the Land Council for the State from Inspector in charge of Kharbal Nagar Police Station, UPD Bhubaneswar. How much time you require, madam?
Lordship, any short date may kindly be fixed. I will file the comprehensive affidavit.
Whether 25th of November would do or you want some more time?
No, Lordship, 25 will also do, Your Lordship.
We commencing from 25th November 2024.
Grateful, Your Lordship.
Item 21.
21, my lord, the appellant is inside custody more than 10 years, 9 months. The case is
just a minute. Your bail application was earlier rejected or not?
no.
Okay.
My lord, the petitioner was arrested on 15/12/2010.
Just taking note of it.
My lord.
2024. How many appellants are there?
Present in the present appeal, 1 appellant.
Sushant Behra.
Yes, Your Lord.
And what is the date of custody?
Initially arrested 15/12/2010 and released on bail by this honorable court in BLFL 2463 on 23/9/2020. So that during the UTP period was 9 years, 9 months. And the judgment
date केबे custody गले
15/12/2010
15/12/2010 रे custody गले release हेले केबे
23/9/2020 judgment pronounced
23/9/2020 okay judgment केबे pronounced
15/11/2023
judgment 15/11/2023 तापरठू अछंती
तापरठू अछि total period होची 10 वर्ष 9 मास
10 years 9 months.
Yes, sir.
Okay. So offense is under section
302/201 and
25/27.
25 and 27 of the answer. Okay.
302/201 34 or 25/27 answer.
You please come to the paragraph number 2 of the impugned judgment. Let us see what is the prosecution case. Paragraph 2 टा बाहर कौन तो judgment
Yes, sir.
वाक्यम रू पढ़ो এটা running page होची 28 internal page is 2 paragraph number 2 prosecution case
The prosecution case in brief is that on 26/11/2010, night at 11 p.m., as per direction of OIC Seragar PS by CC number 83 Brahmar Tarai, ASI Police Station, C for Sasan Church, PS for patrolling duty in PS Jeep by number registration number such and such bearing driven by a HG 452 H KCH Gouda while they were performing patrolling at
Takarada
Road on 27/11/2010 at about 3 a.m. They found that Sri Manoranjan Mishra, OIC Seragar PS in uniform, is lying dead on the roadside near village Takarada Canal Bridge with gunshot injuries on his body. The ASI found that four numbers of empty cartridges, one live cartridge, and two numbers of fired bullets lying near the dead body. At a little distance, a black color Pulsar motorcycle bearing registration number such and such of the PS, a pair of slipper and a Mauser were also found lying on the roadside. On inquiry, it came to light that Sri Manoranjan Mishra, OIC Seragar PS, had left PS in the same night at about 11:10 p.m. in black color Pulsar motorcycle bearing number such and such in police uniform towards Seragar market and village Takarada to perform night patrolling duty. As such, the ASI Sri Tarai confirmed that some unknown culprit has committed murder of his OIC Seragar PS on the Takarada Canal Bridge road by firing by means of a firearm in the night of 26/27/11/2010. Hence, he lodged the written report before the SDPO ASCA, who was present at the Seragar PS and a registered Seragar PS directed Inspector J.K. Patnaik IIC.
FIR against unknown person.
FIR against
Yes.
unknown.
Then what materials were collected during course of investigation?
During course of
Against
investigation, the pistol, the Mauser, which was
is there any eyewitness to the occurrence?
no, my.
So if there is no eyewitness, then what are the circumstantial evidence?
Circumstantial evidence that just before the arrival of the deceased in the pawn shop of Dhoba Patra, pawn shop of one PW 4 no 7 na se sorry PW 4 Dhoba Patra.
PW4 is a Beetle shop owner.
Beetle shop owner. From his shop, he is saying that two persons purchased cigarette, cold drinks, and gutka. And out of those two persons, he correctly identified the another accused, Samir Panda, but could not identify the present petitioner. Sorry, present appellant. Similar evidence is also by the PW12, who was also participated in the TI parade.
PW11.
PW12.
12.
Yes.
Mane 4 and 12.
4 12.
12 भी थिला से जगह रे.
TI parade हाँ 12 भी थिला.
सी भी आपन को आइडेंटिफाई करनी.
सी आइडेंटिफाई करनी.
अच्छा. এই ଦି ଜଣ
PW7 sorry PW7
not 12
7 12
ଆଉ 3 ଜଣ
ଆଚ୍ଛା ପ୍ରଥମଟା କହି
ଠିକ ସେ କୁହନ୍ତୁ
ନା ନା ସେଟା ପ୍ରଥମଟା 7 ଟା ମୁଁ ଭାବିଲି 4 ପ୍ରଥମଟା 7
ବିଟଲ୍ ଶପ୍ ଓନର ଟା କିଏ
ବିଟଲ୍ ଶପ୍ ଓନର ହଉଛି PW4
7 କିଏ ପୁଣି
7 TI parade attend କରିଥିଲା
12 କିଏ
12 another TI parade witness
there are three witnesses appearing before the TI parade
PW12 not identified PW7 also not identified
no
ये जो तीन जण विटनेस आपन को टीआई पैरेड रे भी आइडेंटिफाई करनाती एवं कोर्ट रे भी आइडेंटिफाई करना ठीक तो
यस
4 भी थला टीआई पैरेड
हमरे 4 7 and 12
तीन जण पार्टिसिपेट करले किंतु ना टीआई पैरेड रे आइडेंटिफाई करजंती ना कोर्ट रे आइडेंटिफाई
PW4 रो एविडेंस so far TI parade is not specific it's saying that accused persons but 7 is specific
कोर्ट रे चिनी पान
Court ko I attend the TI parade in the Aska jail. In the TI parade, I identified Samir Panda and Sushant Babu.
Sushant
That is PW4 statement. Para 2.
Wrong. PW4 para 4.
No, identified accused Samir Panda only question.
And Sushant Babu.
Para
2. I attend the TI parade. At Aska jail, in the
Oh,
TI period,
four-
I identified Samir
four.
Ponda and Susan.
Correct,
Susan.
correct. Yes, yes, yes.
Yes, yes.
The
Yes, yes. I'm sorry. I could not notice.
accused Samir Panda. I know the accused person standing on the dock. So identify he.
Charge sorry, ମୁଁ ଦେଖିନଥିଲି
So
ସେଠି।
PW
But seven-
has identified you. It's not that, but ଆପଣ କହୁଛନ୍ତି 7 ଆଉ 12
7 ଆଉ 12
ହଁ
7 ର ଏଭିଡେନ୍ସ ମୋର
ଆଚ୍ଛା, ସେଇ
ବ୍ରିଫ
ଯୋଉ 4ଟା ଯିଏ ଆପଣଙ୍କୁ ଆଇଡେଣ୍ଟିଫାଇ କଲା
Beetle Saponer.
ହଁ
That Beetle Saponer, ଯୋଉ
ହଁ।
cigarette ପାନ ଆଣିଥିଲେ।
ସେ କଣ କହୁଛି ଆପଣଙ୍କ ନାଁରେ କଣ ଓଭରଟାକ୍ସ କଣ କହୁଛି PW4 କୁ ଆସନ୍ତୁ।
ଆସିଛି PW4
ସେ ତ यही ऑस्ट्रेलिया।
Australia।
I know all the accused persons standing on the dock. The witness duly identified the accused Samir Panda. The occurrence took place about 5 years back at about 11 to 12 a.m. In front of my metal shop situates at village Takarada. Samir Babu and Sushant Babu came near my shop and walked up to me and asked me cold drink panno and also asked me 4 cigarettes. I gave them the cartridge and cigarette.
No, the cold drinks,
And cigarette. They smoke cigarette and they paid me the cost of cold drinks and cigarettes. I have to return 2 rupees. Instead of paying rupees 2, I gave them 2 sada pudia, a matchbox. At that time, police came near my shop and told me why I had opened the shop at 12 night. I heard 2 sounds. The police babu told Morigali mo pilla bhasigale. Thereafter, out of fear, I
went
to my house. I attended the TI parade at Aska jail. In the TI parade, I identified Samir Panda and Sushant Babu. This is my signature marked exhibit 3/1 in the TI parade at Aska jail. I attended the TI parade to identify the material object before the magistrate Aska, where I identified one black bag. This is the said bag marked MO2. I put my signature TI parade marked exhibit 4/1. Thereafter, he was turned hostile and he was cross-examined by the prosecution.
It is a fact.
Here, yes. Here, my lord, before going to that, I press upon the first paragraph which I started. He is identifying, he has mentioned that I identify both of them, but in the court, he is saying that I identify the accused Samir Panda only. He is not saying anything with regard to present appellant in the court. I was examined by the police. It is a fact I have stated before IO that out of fear, I saluting the Babu while I was closing my shop. Thana Babu called those 2 persons near him, and while he caught hold of the neck of not fair complex boy, they caused do sounds. It is a fact I have stated before the IO that he fell down on the ground. It is a fact I have stated before the IO that seeing this, those 2 boys took away the motorcycle of Mishra Agya and fled away towards Hinjilkot. They non-looking fair complex. It is not a fact. I am suppressing the truth and fearing in the court. So it is at this he is also saying that they took the motorcycle, those 2 accused persons, whereas the report says that the motorcycle was lying near the dead body. And PW7, your lordship will come to page. I have annexed.
You were there present at that scene of occurrence, and the PW4 has identified you, and the deceased also came, and he said that challenge that victuals of honor, and then immediately those sound were heard, and the dead body was found, এবং he କହିଲା ଯେ ମୋ ପିଲାମାନେ ଭାସି ଗଲେ। ତ ଅଛି ଆପଣଙ୍କ ନାଇଁରେ material ନାହିଁ ବୋଲି କହିହବନି ତ and he's a IIC or somebody who
near about 11 11 years already inside custody.
Also 10 years.
And other materials are there which was also not clinching. So far the role of the present appellant.
Afterwards, in moving, there are 24 of 50. IA number so and so is an application for bail. The land counsel for the petitioner submitted that the petitioner was taken into judicial custody on 15/12/2010 and he was released on bail on 23/9/2020 by virtue of the order of this court. And on the announcement of the impugned judgment by the London Trial Court on 15/11/2023, he was again taken into judicial custody. And as such, he is in custody for about 10 years and 9 months. And since it is a criminal appeal of the year 2024, there is no chance of early hearing. It is submitted that the first information report was lodged against unknown persons. And 3 persons participated in the TI parade. And PW7 and PW12 could not identify the petitioner. However, PW4 identified petitioner in the TI parade, so also in court, but he has not supported the prosecution case fully, for which he has been declared hostile. Land Counsel submits that in view of the available material on record, there are no chances of
PW18 में can live glass. That is it. After
success
receiving some
and balance of convenience is in his favor. And therefore, the bail application may be favorably considered. Land Counsel for the state submitted that the evidence of PW4 is very clinching.
18 also.
Yeah, 18 also.
18 also. 18 are more clenching than
18.
So also PW18
identified TI parade.
who has identified the petitioner
TI parade and in court also.
as well as in court. He further submits that it is the commission of murder of the OIC of Sergarh Police Station, Manoranjan Mishra, and bail should not be granted to the petitioner who has utilized the firearm to kill the deceased. Considering the available material on record and the nature of evidence adduced by the prosecution, we are not inclined to release the petitioner on bail. The bail application stands rejected. Stay relation of fine. Yes.
Item 22.
I'm giving a synopsis of fact just to explain.
They're just coming within 2 minutes.
Yes.
Lordship, just to reappraise, I'll take your Lordship through the note. Initially, a writ application, what happened? A land was leased out to one Majhi in 1972, my lords. I'll take your Lordship through the note. Just giving us brief synopsis. 72, it was leased out. Thereafter, he obtained permission and sold it to one Rai. Rai sold it to the present petition. This is in the year 90. 88, she bought the lands and thereafter sold it to the petitioner in 1990. Now, thereafter, what happened? Now, my lords, after 24 years, the ADM initiated a suo motu proceeding under 7A, my lords, revoking the lease, saying that this comes under, this is not tenable, this is not permissible, various factors. We challenged that in a writ application before your lordships. Your lordships held that he has no jurisdiction to revoke the lease application after a period of 24 years, since the period of limitation under 7A is 15 years. So hence, accordingly, the order of the ADM was, my lords, quashed. That remains final and binding between the parties. I'll take your lordship through the order also. That remains final and binding. Now, my lords, I went for correction of record of rights. The petitioner is a captain in the Navy, my lords, in the Merchant Navy. So he was in the seas. He couldn't do much, my lords. In 2013, he comes up and goes for a correction of record of rights in pursuance of the orders of this honorable court. Now, record of rights, they don't do anything. So we filed a writ application before your lordship.
Name that ROR stands.
My lords?
In whose name that was?
The ROR stands in the name of
Government.
So it has been sent to the. It has been government. Government.
Correction according to the High Court order was not carried out.
Because the correction according to the High Court's order was not carried out, it was sent to the government. Thereafter, we filed a writ application before your lordships for correction of record of rights. Now, they did not do anything in the matter, so we filed a contempt application before your lordships. In the contempt application, your lordships gave a direction that within 6 weeks, they have to dispose of the matter. Now I'm taking your lordships to the then they pass the impugned order, and I challenge it again before this honorable court. This honorable court says, as it is an appellable order, you can go up in appeal. So against that order of this honorable court, in this writ application, I went to the Supreme Court. Supreme Court has remanded the matter back, saying that all issues are to be decided by your lordships. I'll take your lordships now through the orders.
Now, what issues are remain to be decided?
My lord,
the order stands now.
That order stands now.
Only whether your name is to be entered into in the ROR or not.
Exactly, my lords. And this honorable court had remanded the matter. The Supreme Court says no, all the issues. I'll take your lordship straight away to the order of the honorable apex court.
So you are ready?
Yes, sir.
Yes. Okay.
Flag 10. It is at flag 10 of your lordship's brief, my lords. Lordship gets it?
Yes.
My lords, the second page, these civil appeals are directed against the order dated 3/3/2017, passed by a division bench of the High Court of Orissa in writ application number 1889 of 2017, whereby the appellant's writ petition has been dismissed with a one-line order that since the order of the Tahsildar against which the writ petition was filed is appellable, the appellant should file an appeal before the appropriate forum, and hence the writ application was not entertained. The second impugned order is dated 17/3/2017, whereby a typographical mistake in the earlier order dated 3/3/2017 has been corrected and the words contempt petition have been substituted as writ petition. The controversy pertains to the ownership, proprietary and possessory rights of the appellants over land measuring 3.75 decimals, to which the appellants claim themselves to be a bona fide purchaser. It is urged that the Tahsildar erroneously refused to mutate the land in favor of the appellants on the basis of the ADM's order, which had in fact been set aside by the High Court in the previous round of litigation, that is writ petition number 14429 of 2006. Learned State Council, on the other hand, submits that the original lease granted in favor of Sridhar Maji was rightly cancelled. We have heard learned counsel for the parties for some time and perused the material on record. Since we do not have the advantage of a reasoned order of the High Court and the writ petition has been dismissed on a hyper-technical ground, and looking to the fact that the appellants claim to have acquired ownership rights way back on 9/5/1990, we deem it appropriate to set aside the impugned orders and remit the case to the High Court with a request to decide the writ application on merits without all the contentions raised by the parties are kept open with liberty to raise the same before the High Court. It is clarified that we have not expressed any opinion on the merits of the case. The appeals are allowed in above terms. The parties are directed to appear before the High Court on 22/4/24. Request the High Court. This is the order passed.
So the matter which has been remanded is that WPC number 1889 of 2017.
Yes, ma'am.
What is the prayer in that petition?
Prayer for
in this petition, the present petition has been remanded.
Yes,
So
ma'am.
here, what is your prayer?
My lord, the prayer is, it is therefore prayed that your lordships may graciously please to admit the writ petition, call for the records in WL Miss Case number 23 of 2000, issue rule nisa in the nature of writ of certiorari mandamus, calling upon the opposite parties to show cause as to why the order dated 7/1/2017 passed in WL Miss Case number 23 of 2013, wide Annexure 7 shall not be set aside, quashed, and as to why the miscase shall not be allowed, correcting the ROR in respect of the land in question in the name of the petitioner. This is the main prayer, and in the event the opposite party fails to show cause.
So what is that order dated 7/1/2017?
Yes, my lord, that is at Annexure 7.
Page 40.
At running page 43 months. Lordship gets it.
मेरा छुट्टिया order को देखा जाऊंगा।
एटा टिके
तो बड़ा कर लिया फोन 7/1/2000 yes.
The 7/1/2000 case is taken up today. Petitioner is absent. The brief facts of the case is government land to the extent of 0.750 decimals was leased out in favor of Sridhar Maji by caste of village Nijigaon, wide orders by the then Tahsildar in WL case number 771 of 75. And necessary correction was made in respect of the aforesaid mentioned land and Patta wide Khata number 64 of 29. Plot number 226 of 332 Kisam Sarda of Moza Dolwa was delivered to the lessee. Subsequently, the lease revision case bearing number 107 of 98 was so moto initiated by the ADM Khurda under section 7A3 of OGLS Act 1962. The learned ADM set aside the sanction order of lease Wider's order dated 31/3/98 since the settlement of land by the Tahsildar suffers for the legal infirmities and material irregularity. Pursuant to the direction order of the revisional court, the leasehold land, that is 7.50 land in such and such, is brought back to the khata of number 75 of village Dalua. Being agreed, one Shri Madhav Satpati, the present petitioner, wife of Jagannath, should be son of, the present petitioner of this case, who is subsequent purchasers of an area of 0.750 of leasehold land, had again preferred writ application number 24833 of 13 before the Honorable High Court, challenging the revisional authority passed in land revision case number 1078. The Honorable High Court disposed of the writ application on 24/3/2014 with certain direction which is noted below. Taking into consideration the limited grievance of the petitioner, the writ application is disposed of, directing Tahsildar Bhubaneswar to dispose of the aforesaid miscase as expeditiously as possible, preferably within a period of 6 months from the date of receipt of a certified copy of this order, keeping in view the pendency on the board. To carry out the orders of the Honorable High Court in letter and spirit, notice was issued to the petitioner twice through registered post, along with notice served through postcard and through a process server. The RI Medasal was directed by this offer letter number to inquire and report about the field position as well as possession as well as position. Peruse the representation along with copy of order and contempt proceeding filed by the petitioner on 25/11/2016. The operative portion of the order is extracted below. Considering the grievance of the petitioner, this court, instead of keeping the matter pending and directing to file show cause by the opposite party, dispose of the contempt proceeding with a direction that in the event the proceeding pending before the Tahsildar Bhubaneswar has not been disposed of within a period of 6 weeks from the date of communication of the order, failing which the court shall entail an automatic suo motu contempt proceeding. Gone through the documents annexed to the case records and perused all connected papers and report of R.I. Medasal, original case record and present ROR position, it is revealed that the writ petition has prayed to carry out of the Honorable High Court of Orissa in WPC number 14429 of 2006, 24833 2013 and contempt case number 1038 of 2013. It is seen that the suit land has already been resumed to government khata in lease revision case number 10798, which order has been set aside by this honorable court.
Where has been set aside?
In WPC number 14429, I'll take your lordships to that order. The RI Medasal has reported field inquiry report.
No, Mr. Kanungo, just take pause for a moment. In this particular order,
yes,
there is no reference to that order which you are telling WPC number
14429.
WPC number 14429 of 2006.
2006.
2006.
Which is annexure 4.
Which is annexure 4 to this writ application. He refers to that order.
এই অর্ডারে আপন এ পর্যন্ত যেতিকি পঢ়িলেনি ସେଥିରେ ତ କିଛି ଲେଖା ହେଇନି
like khali he says I have asked him to carry out his orders in view of 14429 of 2019 2006 sorry.
Okay.
Your lordship, again I'm going through the last paragraph. Gone through the documents annexed to the case record and perused all connected papers and report of R.I. Medasal, original lease case record and present ROR position. It is revealed that the writ petitioner has prayed to carry out orders of the Honorable High Court Orissa in WPC number 14429 of 2006, WPC number 24833 of 2013 and contempt case number 1038 of 2013. It is seen that the suit land has already been resumed to government khata wide order in lease case revision case number 107 of 98.
14429 of 2006. Where is that order?
My lord, that is at annexure 4.
Just show the operative portion, then we'll proceed.
Yes, one. Again, এটা হলো page 34. Sir, second paragraph, in the decision rendered by this court, your lordship gets 34.
Yes.
In the decision rendered by this court in the case of Purnachandra Pradhan versus State of Orissa and others, we held that the limitation prescribed under second proviso to section 7A of the OGLS Act cannot be extended and no suo motu revision can be initiated after expiry of 14 years from the date of grant of the lease. Since it is clear from the impugned order that the additional district magistrate Khurda has exercised his power under section 7A of the OGLS Act, much after expiry of the period of 24 years from the date of the original lease, the impugned order under annexure 3 is unsustainable. We accordingly quash the order dated 31/3/98 passed by the ADM Khurda and lease revision case number 107 of 98 under annexure 3 and allow the writ application.
That means that order has been set aside.
Exactly.
This order has not been challenged in the higher court.
No, my lords. This remains final and binding between the parties.
Okay. Just 2014, 11, 2006, na?
It at 2006, sir.
Okay. Now you come to that order. Jota poduthile apna.
Ha, sir. Eta hela page 49 ର second paragraph ଟା. Gone through the documents annexed to the case record and perused all connected papers and
Just a minute. Jota poduthile apna. Annexure.
sir eta hela annexure 7. At page 44. Second paragraph. The operative, Olga Gurate, he's just giving a year. Gone through the documents annexed to the case record and perused all connected papers and report of R.I. Mendhasal, original case record and present ROR position. It is revealed that the writ petitioner has prayed to carry out the order of the Honorable High Court of Orissa in WPC number 14429 of 2006. The order that I placed before your Lordship. 24833 2013 and contempt case number 1038 of 2000. It is seen that the suit land has already been resumed to government khata by order in lease revision number 107 of 98. I pause here for a moment, Malos. That has been what? The R.I. Mendhasal has reported field inquiry via his office letter number 769 by 31/12/2016 that the land has not been used for the purpose for which the land was leased out, that is agricultural purpose. The land presently falls barren. Neither anybody is cultivating nor any structure, boundary wall constructed over it. The inquiry report made by R.I. Mendhasal forms part of the case record. Further, the R.I. Mendhasal has reported that during the time of field inquiry, villagers of Dolwa Moja vehemently opposed that government land should be alienated to any person or in any manner. The land is a valuable government land, can be used for development purpose by the government for expansion of the capital city and greater interest of general public. The land has already been resumed. Page 45, Malaj. The land has already been resumed to government khata as per material irregularity and legal infirmities noticed by the ADM Khurda and land revision case number 107 of 98. He again refers to that ADM's order, Malaj, which is contumacious. In the instant case, it is found that the land is fallen barren and the present petitioner of the lessee is not in peaceful possession of the suit land. It is pertinent to mention here that the original lessee, being aware of the legal status of the leasehold land, has never challenged the order of the revisional authority. Rather, he is silent over the matter since the date of cancellation of lease. The sequence of events and development in the instant case reveals that the present petitioner, being the subsequent purchaser of the leasehold land, has been attempting to grab valuable government land since the year 98 to 2017, suppressing real facts in issues and misleading the honorable court for passing orders vesting proprietary rights in his favor. He says we have misled this court. The Tahsildar goes out because a contempt proceeding has been initiated against him. That is why, my lords, he goes out of his way to give such an order.
No. Why the matter came to before the Tahsildar? Because of the order of this court.
For correction of record of rights. Initially, my lords, when we had
the correction of the record you have filed because of that division bench decision of this court.
Yes, ma'am.
There he has done all this exercise.
Yes. And a subsequent order for first order, this lease was continuing. The ADM invokes his power under 7A, tries to cancel the lease. This honorable court set aside the act of the ADM.
That is 2006.
Then, yes. Then, my lords, say order.
Correction of the ROR.
Order was pronounced in 2006.
98.
No, this
court, Chief Justice.
Thereafter, my lords, he was, as I was saying, he was in merchant navy, so he was not in India. He was traveling the seas.
And your permission letter for the purchase of land?
Permission letter has been given to one Mrs. Rai.
Where is that?
That is not with us, my lords. That is no one's case.
No.
He is the subsequent purchaser.
No. When a leasehold land is transferred in favor of someone, permission is required or it is not required?
My lords,
where is that?
They have obtained due permission.
Where is that?
So in 2006, the matter, who is the petitioner? You are the petitioner?
Yes, Madhav Chandra Saraswati.
I was the petitioner.
Yes.
I'm a permission nahi ki lease deed kar and that is never a ground for setting aside the lease.
No, that is different.
Page 20.
Page 27.
Have you annexed the original lease also? Original lease has been annexed.
No, my lord.
Record of rights.
No, lease.
Lease ଟା ଯୋଉଟା ଦିଆ
No,
ହେଇଥିଲା ଆପଣ ଯାହାଠୁ
Original lease.
ସେ ଯୋଉ ମାଝି ଶ୍ରୀଧର ମାଝି
no, my lord.
ଯୋଉଟା
Not
କି WL କେସ୍ ନମ୍ବର 77172 ରେ ଆପଣଙ୍କର ଯୋଉ ତା ନାଁରେ ବି ହେଲା ଯୋଉ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଦେଲା ତାକୁ ଲିଜ୍ ରେ ସେଇ ଅରିଜିନାଲ ଅର୍ଡର ଟା ଅଛି ଆପଣଙ୍କ ପାଖରେ?
Sir, ଏଇଟା ଆମ ପାଖରେ ଶ୍ରୀଧର ମାଝି ନାଁରେ ରେକର୍ଡ ଥିଲା।
ହଁ ସେଇ ଶ୍ରୀଧର ମାଝି ଯେ ଶ୍ରୀଧର ମାଝିର କେମିତି ପାଇଲା ସିଏ? ଶ୍ରୀଧର ମାଝି ଆପଣ କହୁଛନ୍ତି ନା
ଆଜ୍ଞା
WL କେସ୍ 72 ରେ ପାଇଲା ସିଏ,
ଆଜ୍ଞା
771 of
ଆପଣଙ୍କୁ
72.
ସେଇ ବେସିସ୍ ରେ ସିଏ ଆପଣଙ୍କୁ ସେଲ୍ ଡିଡ୍ କରିଛି
ନା ମତେ ନୁହେଁ ରଶ୍ମି ରାୟ
ଆଉ ଜଣକୁ
ଆଉ ଜଣକୁ ତାଠୁ ଆପଣ ପାଇଛନ୍ତି।
ତାଠୁ ମୁଁ କିଣିଛି।
ତ ଆପଣ ବର୍ତ୍ତମାନ ଆପଣଙ୍କ ନାଁ ଯୋଉ ରେଜିଷ୍ଟର୍ଡ ହବ ତ ଫାଷ୍ଟ
Source
ଟା କାହିଁ ସେଇ ଯୋଉଟା ଶ୍ରୀଧର ମାଝି ବୋଲି?
ଶ୍ରୀଧର ମାଝିର ଆଜ୍ଞା ଅରିଜିନାଲ ଲିଜ ଡିଡ୍ ଆମେ ସାର୍ କୋଉଠି ଆମେ ତ ସବସିକ୍ୱେଣ୍ଟ ପରଚେଜ ଆମେ ତାଠୁ କିଣିଥିଲେ ଆମେ ରଶ୍ମି ରାୟଠୁ କିଣିଛୁ।
All right.
Whether
But vendor
in that is that a disputed thing?
No.
Oh, that is
The
not
ADM lordship sees the ADM's order also. Nothing is disputed.
1 second. So that part is not disputed. That it has
Nothing is
been
disputed.
Actually, here also it is written that in
Written.
no 10/6/2014 the case record is put up today. The petitioner is present
28,
and
right?
filed Hajira. The DA lease has submitted original lease number 771 of 72 attached with this case record.
ଅଛି ସେଟା
Eta achi.
ଆଜ୍ଞା
Where is that? That you have to find.
ସେ ରେକର୍ଡ ଟା କାହିଁ ସେ
That is required.
WL case number 23 of 2013 ଅର୍ଡର
Yes.
ଦେଖିଲେ ଆପଣ?
yes, my lord. I'm on there.
ହଁ
Lordship.
ମାନେ what Mr. Kanungo is making a
My lord.
submission
My lord.
that there is no dispute that the government has granted lease in favor of that Maji.
My lord.
And that original lease deed also was filed in that WL list case number 23 of 2013
13.
Yes,
as
my lord.
would be evident from the order dated 10/6/2024. ଲେଖା ହେଇଛି ନା 10 page 39 ରେ page 39 ରେ
Yes, my lord.
10/6/2014 ର order ଟା ଦେଖନ୍ତୁ।
Yes, my lord. The DA lease has submitted, lessee has submitted original lease number so and so attached to this case. My lord, sir.
The original ground on
wants
which
the
it is
record, may I
taken away
produce
is
that record?
saying that
I'll produce that
forest
record, my
like
lord,
wala.
for your lordship.
Question now is that
Yes.
once this court has set aside
My lord.
now and you have not challenged the order in
My
the
lord.
higher forum,
My lord.
but the question remains is that in whose favor it is to be recorded.
Yes, my lord.
So you cannot sit over the matter,
Yes.
and by passing this order,
My lord.
you are passing an order against the order of the division bench of this court, right?
I bowed, my lord.
So once the division bench has set aside that
My lord.
order that your suo motu revision power beyond the prescribed period of limitation
Yes,
is
ma'am.
not sustainable in the eye of law, that means the lease stands confirmed. So if the lease stands confirmed in favor of the Maji, the subsequent
Title
transfer
will-
which have been made
My
in
lord.
favor of that Rasmi and then to this petitioner
Right.
automatically stands valid if the necessary permission is there in that original lead, there can be transferred.
My lord.
So now it is only the matter that it is to be recorded in the ROR, his name is to be recorded.
My lord,
So
this part,
you
your
cannot
lordship.
now take on the ground that it was not utilized for that purpose.
Yes, ma'am.
For that, a separate proceeding has to be instituted. Suppose it was granted lease,
My lord.
lease is valid, and for the purpose for which it has been taken,
My lord.
it is not being utilized.
My lord.
So then a separate proceeding is to be instituted.
My lord.
The first lease was cancelled on the order was set aside on that ground itself.
My lord.
You are again reviving the same thing once again and passing the order.
And it is only the allegation is that you are misleading. It is not your case that you have committed fraud.
My lord, so
That you
far
can
as
revive
this
it.
point is concerned, my lord, so I'll produce the record to ascertain that original lease deed, my
Yes,
lordship.
And the
And my lord, one.
it is very clear from the 10/6/2014 order. The case record is put up today.
Yes, ma'am.
The petitioner is present, filed Sajira. The DA lease has submitted the original lease number
Yes,
771
771
of
of
72 attached with And
with
that
the
is attached
case
with the
record.
case
This case, yes, my lord. Sorry. That you
So,
see, you
that
filed
is
it.
why the what Mr. Kanungo is making submission
Yes,
that such a lease was granted in favor of that Mazi is not a dispute at all.
my lord. And
Right?
accordingly, it has been dissented through.
Right.
I'll produce that record, my lordship. Kindly see.
If
So-
it is not in dispute, my lords.
Lords, let me verify that at least.
For that permission part.
Yes.
Permission again.
And second, my lords,
No, whether in that Mr. Kanungo, what we
Again.
want to know
Well,
that whether in that lease there is
Any
any
right,
clause
ah.
that you are that original
Can be
lessee has
transferred.
been given right to transfer it
Transfer
to
it,
that. That is the only thing for me.
Because in some
Because
cases,
you are-
Jawans
you are
were not.
because if it is a Jawan lease,
yes.
then that
No,
that-
Jawan lease cannot
ମୁଁ
be.
ଜାଣି ମାନେ ଗୋଟେ କ୍ଲଜ ଥାଏ ଯେ
Right.
ଆମର
It cannot
ବିନା
be transferred.
ପରମିଶନ ରେ
ସେ ଗୋଟେ
ଆପଣ
period
କାହାକୁ
ପରେ। ସେ subsequently permission ନେଇକିରି transfer କରିଛି।
ସେଇ ଜିନିଷଟା
Exactly.
ଦେଖଉନାହାନ୍ତି ନା
ଆଚ୍ଛା।
ଆପଣ
Fail deed ରେ refer ହେଇଛି।
ଆପଣଙ୍କ ପାଖରେ ନାଇଁ ନାଇଁ ସେଲ୍ ଡିଡ୍ ଅଛି ଯେ ତା ଦେହରେ
ସେ
ଆପଣଙ୍କ
document
ପାଖରେ
ଟା, sir।
ଲିଜ୍ ଡିଡ୍ ନାହିଁ ଆପଣଙ୍କ ପାଖରେ ସେ ପରମିଶନ ଲେଟର ବି ନାହିଁ
ମୁଁ sir ଆମର permission ଯୋଉଟା ସିଏ ଇଏ
ଆପଣ ତ କିଣିଲେ ଯିଏ ସବସିକ୍ୱେଣ୍ଟ
ରଶ୍ମି, right।
ରଶ୍ମିଠୁ କିଣିଲେ ତେଣୁ
ତାର
ସେ
ୟାର
ରଶ୍ମିକୁ ବିକିବାର
Permission ଟା।
ଲିଜରେ ପରମିଶନ ଥିଲା କି ନାହିଁ ସେଇ
ଆଜ୍ଞା।
ଜିନିଷଟା ରଶ୍ମିର ଲିଜ୍ ଡିଡ୍ ଟା ଆପଣଙ୍କ ପାଖରେ ଅଛି
Rashmiro lease deed sir, my submission before your lordship is I mean annex 2. Annexure 2. At page 28. At page 28.
No, that's not the least.
ଏଇକି ଆମ पे
ଏଇଟା ହଉଛି ସେ ଅରିଜିନାଲ ଲେସିର ରଶ୍ମି କୋଉଠି ଲେଖା ହେଇଛି ଦେଖେଇଲେ
page ଏଟା କେତେ page 28.
28
ଏହିକି ଆମ୍ଭେ ପୁରାଟା ପଢିଥିଲୁ ଏହିକି ଆମେ ଅନ୍ୟତ୍ର ଜାଗା ଖରିଦ କରିବା
କାରଣେ
କାରଣେ
ଟଙ୍କାର ବିଶେଷ ଦରକାର
ଟଙ୍କାର
ଥିବାରୁ
ବିଶେଷ
ନିମ୍ନଲିଖିତ
ସରକାର
ମାନଙ୍କ ମୁକାବିଲାରେ ଆଗତୁରା ତୁମଠାରୁ ନଗଦ ଏତିକି ବାବଦ ବୁଝି ନେଇ ଋଣ ମଝିରେ ଯାହାକି ରେଭିନ୍ୟୁ ଅଫିସର ରେ ଅନୁମତି ପ୍ରାପ୍ତ ହୋଇ ଆଚ୍ଛା ଏଇଟା ଯୋଉଟା ଲେଖିଛି ଏଇ ଯୋଉ ଲାଇନ ଟା ଦେଖନ୍ତୁ ରେଭିନ୍ୟୁ ମିସକେସ୍ ରେ ଦ୍ଵାରା ଅନୁମତି ପ୍ରାପ୍ତ ହୋଇ 3/16 ରେଜିଷ୍ଟର୍ଡ କବଲା ଦ୍ଵାରା ଲିଙ୍ଗରାଜ ବେହେରାଙ୍କ ଠାରୁ କଣ ଏଇଟା Just you go through it, Mr.
Yes.
Kanungo.
Yes.
यार मानेटा आपण देखନ୍ତୁ ଲେଖା ହେଇଛି କଣ ଯେ ଅନୁମତି ପ୍ରାପ୍ତ ହୋଇ ସେ ସେ ଅରିଜିନାଲ ଟା ଆସି ଯାଉ ନେକ୍ସଟ
ଆଜ୍ଞା
ଆଉ ଆପଣ ବି ଟିକେ ଦେଖି ଦିଅନ୍ତୁ ଏଟା
sir
ଏକ୍ସାକ୍ଟଲି ଏ ଯୋଉ ଲାଙ୍ଗୁଏଜ ଟିକେ ସେମାନଙ୍କର ଲାଙ୍ଗୁଏଜ ତ ସେଇ ଯୋଉ ଡିଡ୍
sir
ରାଇଟର୍ସ
ମୁଁ ବି ନିଶ୍ଚିତ original permission କି records ଗୁରା ବି ଥିବ ଆମ
ସେଟା ଦେଖିବେ
vendor ପାଖରେ
ହଁ ତା ଆପଣ କ୍ଲାଏଣ୍ଟ
petitioner
ପାଖରେ ହୁଏତ ଥାଇପାରେ ସେ
ଆଜ୍ଞା।
ନିଶ୍ଚୟ ଯେତେବେଳେ କିଣୁଛି ଜମିଟା ସେ
ହଁ।
ଲିଜ୍ ଡିଡ୍ ଟା ହୁଏତ ମାଗିଥିବ ତାର କପି ଆଟଲିଷ୍ଟ ଜେରକ୍ସ କପିଟା ସେ ତ ଆଣିବେ ଅରିଜିନାଲ ଇଏଟା
Yes.
ତେଣୁ ଅର୍ଡରଟା ଲାଷ୍ଟ ଟାଇମ କଣ କରିଦେଇଥିଲା Okay. Down. This petition has been filed by the petitioner, Chandra Madhav Satpathy, with a prayer to set aside the order dated 7/1/2017, passed in WL miscase number 23 of 2013 by the additional Tahsildar Bhubaneswar in rejecting the prayer of the petitioner to record the land in his name in the ROA. It is the contention of the Mr. Kanungo and senior advocate that the original lessee was one Sridhar Maji, who sold the land to one Rosmi Roy with due permission by registered sale deed, and the petitioner, who is a Navy personnel and captain in Indian Merchant Navy, purchased the land from the said Rosmi Roy. The initially when the Additional District Magistrate Khurda in lease revision case number 107 of 1998 by order dated 31/3/1998 in exercise of the power under section 7-capital A of the Odisha Government Land Settlement Act 1962, cancelled the lease granted in favor of the original lessee. The present petitioner, with the subsequent purchaser, challenged the order of the additional district magistrate before this court in WPC number 14429 of 2006, and by order dated 14/11/2006, this court has been pleased to quash the order passed by the Learned ADM Khurda dated 31/3/1990 in lease revision case number 107 of 1998. Mr. Kanungo further submits that the said order passed by the division bench of this court has not been challenged by the state, and that is how the same has reached finality. However, in the impugned order, the additional Tahsildar has taken into account the resumption of the land which was done earlier and set aside by this court, has refused the prayer made by the petitioner to record his name in the ROR, which is not proper and justified. When we made a query to Mr. Kanungo as to whether he is having the original lease deed with him, Land Council pointed out from the order sheet of the land Tahsildar. Okay, who order time the Kutulu?
Page 39.
Page 30?
39. 10/6/14.
10/6/14.
From the order of the Tahsildar Bhubaneswar dated 10/6/2014 in WL case number 23 of 2013, that the petitioner submitted the original lease deed number 771 of 72, and that was attached to the case report. At this stage, the Land Council for the state seeks some time to produce the case records of WL miscase number 23 of 2013.
The DA I'm a petitioner actually. Say diary to call for list. Say original list को से diary ये attendant से
The DA lease has submitted.
The DA lease has submitted.
DA lease has submitted. Original so and so it attached to election किए सेटा submit
Sir DA lease हला से diary attendant lease रहो से तांकर कोटे officer
इंट्रा ऑफिस था मैंने
आ गया
अच्छा DA अच्छा यही language टा लिखी थी on the page 39 ने DA lease has submitted and the original lease number so and so was attached to the case record है ना. In view of the submission made by the Land Council for the state, this matter केबे रखिया कौन तो ये record टा खाली आनी है please did
Any day, next week.
let it come on 25th, we commencing, we'll put it in the supplementary list.
As your lordship, please.
So
Yes.
that Mr. Kanungo, you are free in the week in that 25th
25th,
November. The week रे कौनसी दिन supplementary list रे आसिया पाए.
ठीक है, sir.
तेरे कौन सा?
26th.
26th. List this matter on 26th of November 2024. The Land Council for the state shall produce the case records of WL case number 23 of 2013. So that's the order. And
We are also searching.
we are not mentioning anything. You just carry on.
Obliged.
Item 23.
Your Lordships, the council is facing some personal difficulty. A date may be allowed for 2 weeks.
You are appearing for
The petitioner.
counter. What do you say?
The petitioner.
Petition.
The council is facing some personal difficulties.
What your council is having some personal. All right. A mention is made on behalf of Mr. Shivasis Misra. You are mentioning on that for adjournment. Please this matter, give it. Yes.
Item 24.
Item 24, your lordship directed to take some instruction, my lords. I see from the record.
Just let us see that order. Last order is 23/10/2024. Have you got that order with you?
Yes, my lords.
Please place it. 23/10/2024 order.
So that is matter was taken up through hybrid mode. Mr.
ठीक mic adjust करो.
Sorry. Mr. Amitav Tripathi, learned counsel for the appellant, and Mr. Sadasip Patra, learned counsel for the respondent number 1. So also Mr. Abhinaran Mishra, learned AGA for the state. As per the order dated 5/9/24, Mr. Amitav Tripathi, learned counsel appearing for OSRTC, has filed a detailed calculation of area dues under ORSP rules 1998 fifth pay in respect of 16 numbers of retired employees. It is stated that the same has already been sent to the Principal Secretary, Government, Commerce and Transport Department, Odisha, on 15/10/2024. The copy of the same has been handed over to Mr. Abhinar and Mr. Leonard Counsel for the state, who seek some time to take instruction, my lords. That instruction has not come, my lords. Letters have been issued.
Okay. So you want it
Next week, my lord, it will come.
Next week?
Yes, my lord.
So let it come then.
Discuss matter on pending intervention petition is there. Standing, our association has filed. They are standing in the same way as has been.
No, see you 16 जनकर seat आगे clear
Same thing. Same thing. Intervention टा
ठीक है जी ये 19 तारीख के रखो.
Can it be on 20th, so that I can follow up on Monday, Tuesday?
Mr. Prabhu Prashanna Behera, an additional standing counsel, appearing for the state 6 times till next week to obtain instruction as per the order dated 23/10/2024. Place this matter on 20th of November 20. Along with
01 of 2023 will be taken up on that.
सब गुड़ा का आसियो ना आपनकर गुड़ाई मैटर आछि तो